Hey guys, so this is the second of the videos which is have been put together in response to a request I've received. This one was requested by Nick Pick, so thank you. And basically, I have talked a lot in my videos on section 47.1 about the good intentions I feel that the statute has, but how easy it is for it to be exploited, how poorly drafted I think it is. Especially I think Lively has shone a light in these areas in particular. And I've talked about flaws that there are in section 47.1. So Nitpick said, can we have a video on the flaws specifically? So what I have done, and I think the best thing to do here is I put together 8 slides where I'm going to go through 6 flaws that I have found. And these are just my personal opinion. Other people may have different opinions or may completely disagree with me. But this is what I think. These are the flaws that bother me about this law. But I've also removed Lively from it entirely. So, we're looking at this as if it's brand new law and there is it's never been a decision on it. There's no case pending. Nothing. We don't even know about Lively v. Wayfarer. Okay, we're taking Lively away from this entirely and just looking at the law specifically. So there were 6 laws. There were 6 elements I found that bothered me, right? The first is the actual malice standard. The second is the overlap with section 47. So that would be, the other privileges, litigation privilege, etc. The aggressive remedies and the vague scope, mixed motives, and then the lack of appellate guidance. So, the statute's core protection collapses under actual malice requirement. Section 47.1 creates a qualified privilege that applies only when the communication was not made with actual malice. The statute's central operative condition, as confirmed by the Advocate magazine analysis. Now, I will put a link as well, because I went through Advocate magazine. They kind of went through all of this and critiqued this law. So, and I found that really useful, and I've taken some of their thoughts and, like where I've agreed, I agree, where I think, yes, that's right, but actually there's this little bit more. That's what I put in my slides. But I will put a link in the video description to Advocate magazine's analysis of section 47.1 as well, just if you want to read yourself. So the structural problem. Actual malice is fact intensive, litigation heavy standard. It's easy to allege in a complaint and virtually impossible to dismiss at the pleading stage, meaning every defendant must endure expensive discovery before the privilege can be adjudicated. Now, I could be snarky and say, unless you are Blake Lively and you put a complaint before Judge Lyman. Because he did dismiss. Now, in Lively's case, and I am staying away from it, but just to remind everyone, in Lively's case, he didn't actually make a finding at the motion to dismiss stage when he dismissed a complaint. He did not make a finding that there was no malice. And in fact, he actually said that Wayfarer had adequately pled malice. When he ruled on section 47.1, he actually said Wayfarer have adequately pled malice, but there needs to be more evidence. He wanted more. So that's what actually happened there. But again, let's come back now away from Lively. I can see me veering into Lively a lot. The norm is that it's actually incredibly hard to dismiss actual malice at the pleading stage. Lively did seem to be an exception to that rule. So In theory, you would go through discovery at least and get past. Why this is a draft in failure? So the legislator built a statute express litigation, yet tethered it to the least efficient standard for early dismissal. Rather than enabling swift pre-discovery resolution, the statute guarantees protracted and costly proceedings, the very harm it purports to prevent. And again, Lyman's ruling on this now does seem to be a bit of a get around. But then, if you don't have a malice stage, you're going to have a problem for, in this situation where there is either mixed motive or false allegations. The legislator chose a standard that forces the very litigation it was meant to foreclose. So then we move on to, and I will be coming back round to that a bit in the mixed motive part. So then we move on to section 47.1, overlaps with and contradicts existing section 47B and C privileges. This is something I've talked about quite a bit. And the Advocate magazine article noted that section 47.1 was intended to complement the existing privileges under section 47B and 47C. In practice, however, it introduces a third discordant layer that the legislator failed to harmonise with existing law. So section 47B, that is absolute litigation privilege, right? It's not conditional, it is absolute. And it already covers statements made in judicial and quasi-judicial proceedings without any malice qualification, which is what happened with Lively. The comments in her CRD complaint were dismissed on the basis that they were protected by the litigation privilege. There was no need for malice. That's why Judge Lyman did not make any ruling on malice. So it was actually more protective than section 47.1. Section 47C. So that is a qualified common interest privilege, and that already covers workplace and agency communications subject to a traditional malice standard, right? So it's not absolute, it is qualified, it's conditional, and it is subject to a traditional malice standard. 47.1, this is, it's basically a third privilege which introduces a different malice test, right? Not traditional malice, actual malice, which is higher. It brings in different remedies and has a different scope without harmonizing any of the other privileges. So we end up with redundancy. The many communications covered by section 47.1 were already privileged under existing law, rendering the new statute largely superfluous in those cases. So why did Lively need to go for section 47.1 when she'd already had the entire complaint dismissed on two privileges? That's section 47B, the litigation privilege, and section 47D, the fair report privilege, which applied to the New York Times, that latter one. So why does she need to come back for section 47.1? I think headlines. So she can say that she prevailed on a sexual harassment privilege. Because she got nothing more from it other than attorney's fees, which she could have got already. She could have, gone for anti-slap. Just on the dismissal she already had in front of her, she could have done what the New York Times did, what Leslie Sloan did, and she could have applied for anti-slap. Confusion. Which privilege applies? Which malice standard governs? Which remedies are available? Courts receive no legislative guidance. And then inconsistency. Identical facts may attract different outcomes depending on which privilege a court applies. A hallmark of poor statutory design. And that's going to happen with Lively, because the complaint is in regards to Lively specifically. Let's take Reynolds, Sloan, and the New York Times away from it. In regards to Lively, we've already got the litigation privilege applying, the fair report privilege applying, and now section 47.1 applying. But when someone tries to rely on that, which one? because we've got 3. You can see where the differences are between the litigation privilege, because that applies to the CRD complaint, which is a legal document. You can see where then the fair report privilege applies, because that applies to the New York Times article, which is, a mainstream media journalistic article. But now you've got section 47.1. And it's kind of just been put over as another blanket layer. Doesn't apply specifically to either document, and there's no great detail on why it is necessary. The statute's remedies, treble damages plus usually $10,000 minimum for punitive damages. So, and again, the Advocate magazine analysis also confirms that Section 47.1 authorizes an exceptionally aggressive remedial scheme, combining 3 distinct forms of monetary relief without clear limiting principles. So, you've got the treble damages, actual damages, multiplied 3-fold, a criminal-style penalty applied in civil context. Then you've got a minimum $10,000 in statutory damages, regardless of actual harm suffered by the plaintiff. Because normally punitive damages, right? If we think of the Johnny Depp Amber Heard case, right? When they applied punitive damages, the jury actually awarded her an awful lot. They awarded Johnny Depp a lot. Like, it was like millions of dollars, but there was a cap. So Judge Askarati had to cap to the Virginia amount, which I want to say is $350,000. I want to say it's $350,000, but I'm not sure 100%. So, but although let's just say, for argument's sake, that the jury in the Depp v. Heard case awarded Johnny Depp punitive damages from Amber Heard in the region of $5 million. The judge, because there was a cap, a limit, the judge had to then, reduce the award to the highest amount. And that's after hearing all the facts, right? So they awarded actual damages. Then they awarded punitive damages on top. Punitive damages normally have a minimum amount as well. It's like, here's your starting point. How much are you going to give? And usually it starts with $10,000. Punitive damages are kind of optional in most cases. Like, so they could have awarded Johnny Depp damages and then said, look, nothing in punitive. We're not good, because that is specifically designed to punish someone for doing something so egregious, to make a statement to say, look, not only are you going to compensate this person for their losses, for their suffering, or, whatever the actual damages are, we're also going to apply an additional amount, which is just to punish you. You're going to pay this additional amount, and it's just because you have done something so awful. But with Section 47.1, those punitive damages are mandatory. So there's no option of saying, look, yes, have the damages, the actual damages, and times it by 3, and then saying, but we're not going to award any more because, we don't feel a need to punish anyone. No, punitive damages are actually mandatory if damages are awarded, because obviously Judge Lyman did not award the damages, either the actual or punitive damages. So it's his one saving grace is that he found a way to not, because that would have been such an injustice. But also the reason he did that is because he found that the damages portion of Section 47.1 and the attorney's fees portion were severable. So you can treat them separately and decide separately. Now, there's nothing in the legislation that says you can do that. And I know a lot of people are having an issue with that. Like, many people think, well, it should be an all or nothing, because that's kind of what the language of the statute says. it's not that it says it should be an all or nothing. It just doesn't say that you can sever. But Judge Lyman has done that, I think, in some kind of compromise to find some kind of middle ground. Yeah. Okay. So, and then on top of that, then you get 100% attorney's fees. Now, these are, to be very clear, these are reasonable attorney's fees. While we're on attorney's fees, so I know people are, Lively's obviously able to claim her attorney's fees and costs, and I know people are, wondering what is going on. Is she going to try and pull a fast one? My answer to that is I believe she is, but I don't think it's going to be what people think it is. I have a theory on what I think Lively is going to do, which I will do in a separate video, which will be the next video after this. So stay tuned for that, because you will want to see that. But I will lay out, it's not going to be a long video, but I think I know what they're going to do. Based on my own interactions with Lively's legal team, I think I know what they're going to do. I don't know though for sure, so I have to really be clear about that. Don't sue me or subpoena me. But I if I had to take a guess, I think I can see what's coming next. And I just hope that Wayfarer are ready for it. Yeah. So then there is full fee shifting to the prevailing plaintiff, compounding the financial exposure for defendants. Now, these remedies invite due process challenges for excessiveness and create direct tension with anti-slap fee shifting. Because that's all really Lively has managed to achieve. She's managed to achieve what Leslie Sloan has achieved, well, is trying to, and what the New York Times has put before the court as well, is I want my attorney's fees for, being accused of defamation in a case that we successfully defended. A Section 47.1 claim itself can be slapped, producing an ironic procedural collision with the legislator, the legislator failed to address. Okay, so the statute uses vague, undefined language, especially, in quotes, in connection with. Section 47.1 protects communications made in connection with reports of sexual misconduct. Now, this phrase is nowhere drafted in the statute, and the Advocate magazine as well, their analysis acknowledges the provision's deliberately broad scope, a breadth that generates rather than resolves interpretive uncertainty. So the drafting gap. Courts already interpret analogous language in Section 47 very broadly. Without a statutory definition or legislative history, narrowing the phrase in connection with could extend to virtually any communication touching on sexual misconduct, formal or informal, public or private, proximate or tangential. And I said this is one of the examples I kind of made in my last video on Section 47.1 is the absurdity now. Because Jed Wallace has not committed any act of sexual harassment. He was included in an article which talked about Lively expressing, her what happened to her story on sexual harassment, her experience, and it refers to the CRD. But Wallace has never actually sexually harassed Lively. Lively herself has admitted that. And yet, because he filed for defamation, specifically because the way she put him in the New York Times article gave people the impression that he was also, someone who had sexually harassed her. He was just lumped in with the other Wayfarer defendants. And when I read it, I thought, oh my God, he sexually harassed Blake Lively. Because that's how it was read. It was, I don't know whether it was clumsily written by a Pulitzer Prize winning journalist or whether there was some deliberate action behind that. I think I do know, but I don't want to get sued for saying it. But it would not have been unfair for Jed Wallace then to actually sue for defamation, and yet he is now facing a ruling on Section 47.1 because he filed for defamation, and he was included in the article where Lively is speaking out allegedly about her sexual harassment. Shasti Fla was the example I gave in the other video, where she's also in that same article. She's referred to in that article. She is portrayed as someone who has worked with, Wayfarer lawyers, Jed Wallace, etc., and deliberately planned to put out her bump video, etc., and timed it, and did all this damage to Lively. Lively had then had to concede during the motion for summary judgment, the Rule 56.1 statements. Lively had to concede that, Shasti Flat did not work with Wayfarer. Now, if Shasti Flat then went and sued Lively for defamation, well, which there is clear evidence of, because Lively at minimum was reckless had a reckless disregard for the truth. It is very conceivable that, if Lively gets dismissed, successfully defends that, because, I don't know, there's a lack of, can't prove that the statement was made with malice or something to that effect, then Shasti Flack could be sued under section 47.1. That is the stupidity of this law. It does need to be, it's supposed to deter abusers from retaliating against, their victims. It should not be as wide as to reach Jed Wallace. At least I could make some sense of it with Wayfarer, because, insofar as Jamie Heath and Justin Baldoni, because Lively had made allegations about them, right? Whether I believe them or not, whether anyone believes them or not, is neither here nor there. Jen Abel clearly never sexually harassed Blake Lively, and neither did Melissa Nathan, and neither did Steve Sarowitz. But Jed Wallace certainly didn't either. And it is just absolutely crazy that the vague language has allowed it to spread like an awful disease. And clearly we are now seeing it being abused. So categories at risk of litigation. Social media posts referencing an accused individual. Press interviews given before or after formal reporting. Internal workplace gossip among colleagues. Communications to friends, family, or support networks. Public statements not tied to any formal process. The legislator's failure to specify what counts as protected communication guarantees inconsistent judicial interpretation across trial divisions and ultimately across districts, which is what's happened. Now, this is a big one for me. There is absolutely no guidance on mixed motives, anger, revenge, publicity, personal animus, right? And even if we were to take some of Lively's statements as true, there is definitely some, anger, revenge, publicity angles from her. So section 47.1 is entirely silent on whether the privilege applies when the speaker harbored mixed motives. For example, a survivor who reported genuine misconduct but was also motivated by a desire for publicity, retaliation against the accused, or personal animus, or even like extortion. Extortion. Let me produce this film or I will go public with my allegations. Wayfarer clearly were worried about that, and not because they'd done anything wrong. If someone makes a false allegation against you and then says, oh, by the way, I'm going to put it, drop it in a news article and go public with it, that should worry anyone, especially when that person is married to Ryan Reynolds and, has huge reach. So we have the binary problem. Actual malice is a binary threshold, but real human motivation rarely is. Most speakers act from a constellation of overlapping purposes, not a single identifiable intent. I mean, Lively was sexually harassed, allegedly, in May and June 2023. for. She did not file a CRD, May and June 2023. She did not file a CRD complaint, though. Despite everything being fine, in her words, she there was no problem for months during the strikes. And then all of a sudden, she needed to have a meeting about it all again, 7 months later, quite literally. And then she did not file a CRD complaint, despite nothing happening again for nearly 12 months until December 2024. Why? It doesn't make sense. Why do it at that point? Like, why have you not just moved on at that point? If you were going to file something, do it earlier. Do it closer to the time. Walk away from the film. Contact SAG-AFTRA. She had, attorneys acting for her. They negotiated her, employment contracts. They negotiated the 17-point list of demands. It made no sense, right? And the reason she did it was because, she got access to private communications where Wayfarer probably expressed their genuine thoughts about Lively. Did they say anything? No. Did they do anything? No. But was Lively's ego so bruised that she was going to do something anyway? Yes. And we know that from, sort of very end of August, there was some planning in place, and then we had Van Zandt at the end of September. And then we had, a bunch of other stuff happening. And from the text messages in December between Lively and Taylor Swift, where, Lively kind of acknowledges that, the backlash was because, she threw a themed party. Her words. And, references to the New York Times article, which hadn't come out, but was due out in a couple of weeks at this point, being the cancellation of the cancellation. So there was definitely evidence that there was an ulterior motive. The judicial guessing game. Without legislative direction, trial courts must independently determine whether mixed motives defeat the privilege entirely, partially, or not at all, producing inconsistent outcomes. Strategic pleading incentive. Defendants are incentivized to plead secondary improper motives, however minor, as a vehicle for surviving a demurrer and forcing costly discovery. The legislator should have clarified whether good faith reporting must predominate or whether any improper motive destroys the privilege entirely. This omission is a foreseeable source of judicial error and interdivision conflict. And as it stands, we obviously, today, we have a judgment on Section 47.1, whether you like it or not, and it is not appealable. Right? That was part of the stipulation in the settlement. As Lyman does his ruling, there is no appeal from either party. And there was no appellate guidance. And, no appellate guidance plus a new statute equals unstable, unpredictable application. And again, the Advocate magazine notes that the first known judgment under Section 47.1 was issued only recently. That would be Lively. The statute therefore enters enforcement without the interpretive scaffolding that appellate decisions ordinarily provide, leaving trial courts to improvise across every consequential question the statute raises. So the malice standard. No appellate court has defined what actual malice means in the specific context of Section 47.1. or how it interacts with the constitutional actual malice standard from the New York Times against Sullivan. The scope of in connection with. The phrase remains entirely undefined in case law. Trial courts apply whatever reading seems contextually plausible with no guarantee of uniformity. I mean, there's not even a, in terms of, I think I've been sexually harassed. So when Lyman issued his ruling on the motion for summary judgment, he kind of took apart each of Lively's allegations of sexual harassment. He said, "Well, oh, come on, no, this is just a normal scenario. You know, that slow dancing, well, that's quite a that's normal behavior for actors who are, you know, doing a dance and are supposed to be falling in love and etc etc. Or you know, it's quite normal to sit and rely on personal experiences when you're writing a script." And he kind of took apart individually each of Lively's complaints and kind of almost ticked them off as frivolous. And it's like, well, there is no standard here. We don't have a standard. We're applying for sexual harassment and experiencing sexual harassment. So is it supposed to be the objective standard, which is the reasonable person? Because reasonable people will not look at Lively's allegations that she put in the CRD and say, yep, all of that is going to make me feel sexually harassed. We didn't. We read it and we were like, are you really coming with this? Or is it the subjective standard, which is, you know, how Lively feels? It doesn't, that I'm not, it could well be the subjective standard, but there is nothing there to say which standard is being applied. Interaction with Section 47B and C. So no court has addressed which privilege controls when facts satisfy multiple statutory provisions simultaneously. And that bothers me because we've got 3 privileges in the Lively case. And, you know, you can, with the motion to dismiss, the order on the motion to dismiss, you can see where the litigation privilege and the fair report privilege apply in their specific parts. But then where does Section 47.1 come in? What does it add? And then constitutionality of remedies. The treble damages and punitive damages have not been tested against due process excessiveness doctrine, a challenge that appears ripe. The legislator enacted a powerful punitive statute without providing interpretive guardrails, leaving survivors, defendants, and courts alike in an environment of structural legal uncertainty. So just to kind of summarize, each flaw identified above is structural. It says above, sorry, it's because when you go down all the slides. So each flaw identified as structural is embedded in the statute's drafting and cannot be resolved through judicial construction alone. Legislative action is required to restore coherence, predictability, and constitutional soundness. So the actual malice requirement, it makes early dismissal impossible normally. That didn't apply in Lively, but there we are. And it forces the very litigation the statute was designed to prevent. The overlap with Section 47 privileges, it creates redundancy, confusion, and inconsistent application across identical fact patterns. Punitive remedies. They invite constitutional challenge under due process excessiveness doctrine, and they conflict with anti-SLAPP fee shift. Scope in connection with the in connection with statement. That generates litigation over social media, press interviews, informal communications, and peripheral statements. The lack of mixed motive guidance, courts must guess how to treat real-world, multi-purpose speakers, incentivizing strategic pleading. And then the lack of appellate interpretation. The statute is structurally unstable and unpredictable, and trial courts improvise on every key question. These deficiencies are matters of statutory architecture, not policy preference. Reform should focus on harmonising the malice standard, defining key terms, calibrating remedies, and providing clear motive guidance, enabling courts to apply the statute faithfully and consistently. So, there we go. Those are where I think Section 47.1 have flaws. And I will say the advocacy magazine did also make me think about the in connection with statement and how vague that is as well. So credit to that one. I will leave a link to that reading as well. It's well worth a read. But yeah, if you have anything you want to add or anything you want to ask, please do in the comments. As always, always happy. And if you have any videos that you're interested in particular, please let me know.